Let's take a look at civil law. First of all, what is civil law? Well, civil law is really a way to settle disputes. I like to say sometimes it is a way to right a wrong, but it's a legal way for us to settle disputes within society. If we didn't have a legal way to do it, then maybe people try to do it themselves, and maybe we can't reach an agreement. So it's a legal way to settle disputes. There are going to be some vocab words that we use here that we may not use always, in our regular life. A tort's one of those. A tort is just really the civil counterpart to a crime. So in criminal law, we say a violation of a law is a crime. Well, a civil law is called a tort for whatever reason. It's called a tort. So that's just a vocab word that we need to know. You also need to know that 90% of all torts are settled out of court, that we don't actually go to trial to determine that. However, you can go to trial. We have the constitutional right to a civil trial if we're being sued for $20 or more. If nothing else, we can have a judge determine it. If we go to a jury trial and a jury listens to our case to determine, what the result should be, there's a different standard. Okay, and we say that a person being sued is responsible for the injuries or damages with what is known as a preponderance of evidence, which simply means that you believe that they did it more than they believe they didn't, or the jury believes they did it more than they believe they did not. Okay, remember in criminal law, we said the jury must believe a person is guilty or beyond a reasonable doubt. That's the standard that we use, which means that, let's say they're 98% sure that the person did it. In civil law, a civil jury just needs a preponderance of evidence, which essentially means they believe they did it more than they believe they did not, or in civil court, if you're 51% sure the person did it, that's good enough to rule against them. In criminal court, if you're on a jury, if you were only 51% sure the person was guilty of a crime, that's not beyond a reasonable doubt. So civil juries have a lesser standard than criminal juries do. Let's look at some vocabulary. Some of these things are very similar to criminal, but not exactly the same. The defendant is the individual who is being sued. So let's say that you punch me and you break my nose. I'm going to sue you. You are the defendant, then I am the plaintiff. The person who is bringing up the lawsuit is the plaintiff, not the government. Okay, in criminal law we call it the prosecution. In civil law it's the plaintiff, but the government doesn't bring up civil lawsuits. That's the people. So it would be Grody versus you. Is the lawsuit. The judgment is the jury's decision. In criminal law, we'll call it a criminal verdict. In civil law, it's been known as a judgment, or sometimes a settlement. Now, if I sue you, let's say for $1,000 for my broken nose, and before it goes to trial, you and I reach an agreement that you'll pay $800, and I accept that. That's known as a settlement. It didn't actually go to court. The parties settled, similar to kind of like a plea bargain, but not exactly the same. But the idea that it didn't take a jury to make a decision here. It was settled by the two parties involved. Damages are what the winner of the lawsuit is awarded. Okay, sometimes we refer to them as compensatory damages. So you punch me in the nose. Let's say I sue you. Let's say it goes to trial, and I'm awarded $1,000. Well, that's $1,000 worth of what we call as damages. Damages come in a couple different forms. The most common is actual damage. Okay, this should be, let me make a quick change here, suffered by the plaintiff. I should have had that there before. Okay, so actual damages are the actual money lost through this action. Let's use another example. Let's say that you throw a rock through the window of my house, and let's say it cost me $500 to replace the window, but it cost me another $300 to hire someone to do it. So that $500 for the cost of the window plus $300 to hire somebody equals $800. That's how much I'm out because of your action. That's the actual dollar amount that I had to fork out to fix your action. Those are my actual damages. And that's typically what we see in civil law. Occasionally, we will see a punitive damage. Okay, punitive damages are money that is above and beyond the actual damage. So if a jury would give me $800 in actual damages, plus they want to punish you for throwing that rock through my window, so they award me another $500. That extra $500 would be punitive damages, essentially punishment for the defendant. Doesn't happen in like a property case very often, but you do see punitive damages in some kinds of cases. Nominal damages are rarely given. They essentially say that you won the case, but they're only going to be awarded a nominal amount of money, okay, a very small amount of money. And that's what we refer to as nominal damages. Not real common. Not really going to spend much more time on nominal damages because they're very rare. But actual damages and punitive damages are very common. Sometimes an injunction is given. Now, an injunction is a little bit different. An injunction is a court order to either stop doing something or start doing something. And I'll use an example of this. Let's say that this is your neighbor's property. And let's say all of this trash or garbage or junk, if you prefer, is bringing down the value of your home. Let's say you sue. If you're given money, it still doesn't change the fact that all this stuff is here. So that you being awarded money doesn't necessarily right the wrong that your neighbor is doing. So a judge may order an injunction, a court order to do something, or in this case it would be court order to clean up your property. Okay, that may be a way of righting a wrong. And sometimes we'll see injunctions ordered. Liability is, well, legal responsibility from harm. We have a legal duty to act in a reasonable way, okay, with reasonable care towards others. And if we don't, and our actions lead to harm or damage, we may be found liable and sued. So, you're walking down the road. You have a legal duty not to throw a rock through the window of my car, to act of my house, to act with reasonable care towards others. So if you grab a rock and you just throw it and it goes through my window, you did cause harm. You were not acting reasonably. Hence, you may be responsible for the damage done to my house or window. Okay? And we say that you are liable to be sued, or you're liable for the injury or damage. I use the term elements of a lawsuit. I don't know if I made it up or I read it somewhere, but in order to sue somebody, you have to be able to show the elements of a lawsuit. And the elements of a lawsuit are a couple different things. Number one, the defendant acted in one of three ways. And number two, that those actions led to injury or damage. So what are those three ways? Well, if somebody acted intentionally, or sometimes it's referred to as voluntarily, meaning that you meant to do something. Okay, let's say that you're mad at me and you decide that you're going to throw a rock in the windshield of my car. You purposely threw that rock into the windshield of my car. And yes, I do drive a police car. So you throw that rock into there. You're acting intentionally. Okay, that's one of the elements. But what if you don't act intentionally? What if, let's just say that you and your buddy are throwing rocks at birds that are flying by. But you're throwing rocks at these birds that are flying by in a parking lot. And these rocks come down and they damage vehicles in that parking lot. Now, you didn't intend to. You didn't mean to. You didn't even think about it. But you should have been thinking about it. Your actions were foreseeable. Even though you didn't intend to harm anybody, it wasn't intentional. You still should have known that your actions could have caused injury or damage. Throwing rocks in a parking lot, it is foreseeable that those rocks could damage a vehicle. So even though it wasn't intentional, you acted foreseeably, and that needed to be sued. Or a third way is negligently. Negligently is often, or I like to say, is you were doing something you shouldn't have been doing, or you didn't do something you should have done. Okay? Doing something you shouldn't have been doing. Let's say that you drive through a red light, and you run into somebody else. You didn't intend to run into them, but nonetheless you did because you were acting negligently. The easiest way to describe negligent behavior is breaking a law. If I'm driving my car and I'm speeding and I get into an accident and harm somebody, I was negligent because I was speeding. Or if I'm drunk, or if I go through a stop sign, all of those things I'm acting negligently. But you don't have to be doing something illegal to act negligently. This is an X-ray of somebody who left some kind of surgical equipment inside the chest cavity of an individual. A doctor should not have. It may not be illegal, but it was still negligent to leave something inside a body there. So again, if you did something, even if it wasn't intentional, and it may be even unforeseeable, if you were acting negligently, okay, you're acting in a way that is suable. But just because you are acting intentionally, foreseeably, and negligently doesn't guarantee that you can be sued. The second part is there must be injury or damage, meaning that there must be some kind of harm done. If I'm speeding down the road, I'm driving 100 miles an hour down a city street, I'm acting negligently. But if I don't harm anybody, I can't be sued. I can still face criminal charges, but I can't be sued because I did not cause any injury or damage. But if I'm driving 90 down the street, I lose control of my car, and I drive into this fence here, I was acting in one of those three ways, intentionally, foreseeably, or negligently. In this case, I would say that it was probably negligent, and my actions led to injury or damage. Could I be sued? Yes. Okay. So if you can show that the person is acting in one of those three ways and those actions lead to injury or damage, then we have the elements of a lawsuit. You may be liable for the injury or damage here. If somebody is not acting in one of those three ways, I'm going to jump ahead here, but these are the three ways. So let's say that I am driving my car the speed limit down a street. Let's say it's 25 miles an hour and I'm doing that. I'm paying attention to what I'm doing. I'm not doing anything wrong. And let's say somebody is crouched behind a parked car that's parked in the street. And as I'm getting close, they jump in front of me trying to like scare me. And I end up hitting them and they get injured. Was there injury or damage? Yes. Did I intentionally harm them? No. Is it foreseeable that someone would jump out behind a parked car into the middle of the street? I would say no. I drive all the time. It doesn't happen. It's not foreseeable. Was I acting negligently? No, I wasn't texting while I was driving. I wasn't speeding. I wasn't intoxicated. None of those things. So even though there was injury or damage, it still doesn't fit the elements of a lawsuit because you didn't meet this criteria. Okay? If you have one of these three, plus there are injury or damage, then we have the elements of a lawsuit, and then the individual can be sued. There's one more thing that we should go to, though, and that is approximate cause. You can't sue someone unless they're the proximate cause of the injury or damage. So let's use that same example. Let's say I'm driving my car down the street, and let's say this time that I am speeding, and you are going across a crosswalk. Okay, and I run into you. Now, I should have stopped. I shouldn't have been speeding, so I was acting negligently. You broke your leg, so you were injured. You could sue me, but you couldn't sue my let's say that there was a passenger in the car. The passenger in the car was not the proximate cause of the injury or damage because they weren't in control of the vehicle. Okay, you could sue the driver, but you couldn't sue the passenger. Unless, of course, the passenger made that person drive or somehow forced that person, or they were somewhat to blame. How could they be to blame? Well, let's say that I am the passenger of the car and I have a 12-year-old son that does not have a driver's license, and I say, get in the car, you drive, I want to see if you know how to drive. So this is an unlicensed driver that I'm telling to drive, and they get into an accident. I may be the proximate cause because I allowed or told that person to drive that vehicle. Okay, so sometimes the proximate cause is not always the person who did it. It may be stretched farther. Let's use an example. Let's say that I work at McDonald's. My job is to to mop the floor. So I mop the floor, and it's slippery. I know it's got wax and it's soapy, and I don't put any signs up, and I go on my break, and the floor is slippery, and someone walks in and slips and falls and breaks their elbow. The person who was responsible was me, the person who was mopping the floor. But because I am an employee of McDonald's, McDonald's is also responsible for the actions of their employees. So they are also the proximate cause of the injury. Okay? It could be removed from that individual some, but you have to be able to link that individual to somebody else. So if you're going to sue McDonald's for that injury, you got to show that McDonald's is the proximate cause of that injury. Okay? You got to be able to link them. Okay? And we'll get into that more as you get into case studies in class. A couple other terms that we should talk about. Deep pockets is one of them. It's kind of a slang term, but deep pockets means the person with the most money. So if the example that I just gave you, someone fell down at McDonald's and broke their elbow, and let's say that it's going to cost a few $1,000s for surgery or whatever, is that employee of McDonald's, do they have the most money, or is McDonald's, the corporation itself, more likely to be able to pay? The corporation has more money, which we refer to as deeper pockets. Let's use that in the correlation with this. Minors can be sued. So let's say that I'm 15 years of age, I'm in a car, I get in an accident, and I harm you greatly. Because I'm 15, I can be sued. But you could also sue the minor's parents. Who do you suppose has deeper pockets, the 15-year-old or the 45-year-old parent? Chances are the 45-year-old parent has deeper pockets. So even though you can sue the minor, typically the parents, because until you are 18, parents are responsible somewhat for your actions. The parents could be sued. They are the proximate cause of the child's actions. At least oftentimes they are. Couple more terms here that we're going to go over, and then we'll stop here on these notes. One is a class action lawsuit. And a class action lawsuit is when many, possibly hundreds, could even be thousands or more, people sue together in a group, and then they split those damages that are awarded to them. So let's say that everybody in this class, let's say there's 28 kids in this class, and I think it would be funny to put off a smoke bomb in class. And this smoke bomb has noxious fumes in it, and it makes all of you very, very sick and leaves you with health problems. Well, literally, I harmed all of you. You could all sue me individually if you wanted, or you could sue together as a class. Okay, a class is a group of people that sue, but you're going to split the damages equally. So maybe one person was really sickened by this and spent months in the hospital dealing with it, and somebody else was sickened only for a small amount of time and only spent a day in the hospital. If you sued as a class, you both would get an equal amount of damages. They're not always fair, so they're usually split equally. We see a number of class action lawsuits. We'll look at some examples of those in class 2. A contingency fee is when a lawyer doesn't charge you an hourly wage, but instead takes a portion of the damages awarded to you. Typically, it's around 40%. So if I am injured and I have $100,000 worth of damages, and I hire a lawyer on a contingency fee, if the lawyer loses, they don't take any money at all. I don't have to pay them. If they win, though, they're going to take, in this case, $40,000. So it is not uncommon to see someone working as a contingency fee, and we'll look at some cases with those too. Okay, so again, we go back to here. If the plaintiff loses, the lawyer doesn't receive anything. If the lawyer wins, they get a percentage of the winnings, usually fairly high. Now, if you hire a lawyer on an hourly fee, they're just going to charge you a flat fee. Win or lose, they're going to charge you that amount. Comparative negligence is the plaintiff only gets a portion of the money because they're partly responsible. Okay, so let's say that I am driving a vehicle. Let's use an example. I'll use one of these in class. Let's say that I am intoxicated and you are intoxicated, and I decide to ride with you in a car, and you get into an accident and I'm injured. Now, you're the driver of the car and you're intoxicated, so you were negligent to be driving that car. Okay, and it caused injury or damage to me. But no one forced me to get into the car. So I may be somewhat to blame for my own injuries. So the judge may say that, yes, the driver was responsible, but the passenger was 50% to blame for their injuries. So if I had $100,000 worth of injuries and I am found to be 50% responsible, I only win 50% of what I'm suing for. Comparative negligence can be split up among multiple defendants, but sometimes the plaintiff is somewhat to blame for the injuries or damage that occurred to them. And we'll see cases of those too. There's also something known as assumption of risk, in which it's a defense in a negligent lawsuit, in which basically it says that even though the plaintiff was injured, they knew going into it that they might be injured. Okay, so they assumed that they could be hurt. Now let me give you some example. Let's say you play a sport. Okay, let's say not playing a sport. Let's say you go to a baseball game and you're sitting out here and you get hit by a foul ball. Chances are you can't sue because you know when you go to a baseball game that you may get hit by a foul ball. There is an assumption of risk there. Or if you play sport and you get injured playing that sport, you can't sue the school because you know going into that sport that you may be injured. Okay? We have assumption of risks in different activities that we do. Sometimes the assigns may give us an assumption of risk, but we know there is some. So just because you're injured doing something doesn't mean that you can sue, because you may, or doesn't mean you'll win, because maybe there is an assumption of risk, and that's why you were injured. Or you knew that going in, hence you don't get to sue for that. All right.